Hi, my name is Lisa Sumner, and I am a member of the Creditors' Rights team here at Nexsen Pruet. In this video, I will talk about the impact of Chapter 12 bankruptcy on debts owed to farm lenders. Chapter 12 of the US Bankruptcy Code was enacted in response to the farm crisis in the 1980s. It provides qualifying family farmers with a more streamlined and less expensive way to reorganize their finances than in a Chapter 11 bankruptcy case. If you are familiar with how Chapter 13 bankruptcy cases work, then you'll see that Chapter 12 has many similarities. Chapter 12 allows financially distressed individuals, whether married or single, corporations, limited liability companies, or partnerships, to propose and carry out a repayment plan to make installment payments to creditors over 3 to 5 years. If the bankruptcy court confirms the plan, the bankruptcy case remains open for the duration of the plan and then closes. But long-term secured debts continue to be paid after case closure. A bankruptcy trustee is appointed in every Chapter 12 case when the petition is filed, but the trustee's role is limited. The trustee does not take over farming operations, which are left in the debtor's control. The trustee will work with the debtor and creditors in an effort to develop a plan of reorganization that will allow the debtor to retain some or all of its property and avoid shutting down the farm. Immediately upon filing a Chapter 12 petition, an automatic stay is imposed to bar creditors from collecting pre-petition debts or exercising rights against collateral owned by the debtor. In addition, in Chapter 12 cases, a co-debtor stay springs into effect on the petition date and bars collection efforts against individuals who co-signed or guaranteed a loan to a Chapter 12 debtor, even though the co-debtor did not file a bankruptcy petition. However, the co-debtor stay only applies to consumer debts. Debts incurred by a family farmer in connection with his or her farming operations are considered business debts, so the co-debtor stay usually does not apply to farm-related debts. A Chapter 12 debtor is not supposed to pay any debt that arose before the bankruptcy petition was filed, unless and until such payment is approved by the bankruptcy court. However, secured creditors are entitled to adequate protection during the bankruptcy case. Adequate protection is designed to protect a secured creditor if the value of the creditor's collateral declines during the bankruptcy case. For example, if a creditor with a security interest in farm equipment can prove that the value of its collateral is decreasing by $5,000 per month, the creditor can file a motion for adequate protection. Forms of adequate protection in Chapter 12 commonly include periodic cash payments to the creditor equal to the decrease in value of the creditor's collateral, replacement liens or liens on additional property. A Chapter 12 debtor might provide adequate protection to a lender with a lien on the debtor's real estate by paying the lender the reasonable rent customary in the debtor's community for similar real estate. If a creditor is substantially oversecured, this equity cushion can itself provide adequate protection. If the debtor cannot adequately protect the secured creditor's interest, the bankruptcy court may grant the creditor stay relief to foreclose on the collateral. It's fairly common for a Chapter 12 plan to propose selling some of the debtor's excess equipment and land to downsize operations and generate cash to reduce debt. One significant benefit of Chapter 12 is the debtor may be able to discharge capital gains taxes incurred from the sale of farm property. The net sale proceeds are paid to creditors holding liens on the assets that are sold. If a consensual Chapter 12 plan cannot be developed, the debtor may propose to surrender collateral to the secured creditor. This is sometimes called a dirt for debt plan. Alternatively, a debtor may choose to retain a secured creditor's collateral and seek confirmation of a Chapter 12 plan over the creditor's objection to the plan's payment terms. This is what's known as a cram down. In such cases, the secured creditor retains its lien, and the debtor pays the secured creditor the present value of the collateral, rather than the face amount of the claim. The amount of the claim in excess of the collateral value is treated as an unsecured claim, which does not have to be paid in full. If you have any questions or need more information, please call me or any of the other members of the Creditors' Rights team here at Nexsen Pruet.